This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
I go back to what I said before about using common sense. Some inconsistencies. Let's talk first about inconsistencies in various statements the witnesses made, the testimony at trial, in prior statements. And sometimes an inconsistency is a kind of glaring inconsistency. It's not one that you would explain by the passage of time. It's not one it's not the kind of change of testimony you would expect just because a witness. If you tell a joke 3 times, you're going to tell it 3 different ways. You know, and the same thing in telling a story. But some inconsistencies are of such significance that it does question whether the statement that's being told in court is true. When it comes to inconsistent statements among witnesses, once again, you're going to be evaluating credibility of each one of the witnesses and determining whether they're both telling the truth, whether there's a reason based on all the factors that we've talked about to believe one witness over the other. But sometimes, you know, for example, if it's an identification case, the issue is this the person who committed the crime, say a robbery or whatever. If it's a one witness identification and the victim of the robbery says that's the person who did it, and there are 1 or more witnesses who are alibi witnesses who say the defendant was somewhere else at the time, and their testimony is sufficiently plausible that it creates a reasonable doubt, then that's a reason to find the defendant not guilty. So the answer, I think, in both of these situations is apply common sense and keep in mind the burden of proof.
So if I could add something there, there are 2 different ways that inconsistency becomes important. One is when something is actually different from a previous statement. The person said before the light was red when I came to the corner, and then comes to trial and says the light was green when I came to the corner. Those are 2 just irreconcilable differences. And usually when there's a direct contradiction, the factor that has to be considered is how important is that contradiction. If it's a minor fact, you might think, well, they got one minor fact confused. They're still basically telling the truth. But if it's a major fact, if that was the center piece of the case, if that was the heart of the case, was whether the light was green or red, and they got it differently 2 times, there you'd have to conclude we can't rely on this person's view because they got such an important fact wrong, or at least inconsistent. The second type of inconsistency, which is more complicated to deal with but comes up all the time, is when it's not actually inconsistent, but there is an omission from an earlier statement, where something is left out of an earlier statement that logically you think would have been included if it was true. So for example, a witness describes some kind of crime, gives a statement, then comes to court and adds an important fact that wasn't in the prior statement. It's not inconsistent with it, it's an additional fact, but an important one. And then you come to the question, why was that fact omitted not included in the prior statement? Are they making it up later to fill in the story? So, quick example. In my prosecutor case that I mentioned, the star witness who testified for the prosecution gave a very incriminating version of the facts against my client. When he came to trial, he added an incident that had never been in his 4 years of statements. There had never been this statement before. It was an additional allegation against my client that he had attended an extra meeting where incriminating conversations supposedly took place. And that meeting had never been discussed in the prior statements. So it didn't contradict the prior statements, but it was absent from the prior statements. And this led to a debate that we played out. And my position was, you can't rely on this additional meeting, because if it were true, it would have been included right away, because it was too important to omit initially. So he must be making it up now. The government said no, it's just something he remembered later on. He's not lying, it's true, it's something he remembered later. So this debate about inconsistencies applies to both direct inconsistencies and inconsistencies by omission. And again, there's no magic answer to either of them. You have to weigh the importance and use your common sense to judge credibility.
I mean, one of the things you might look at, correct me if I'm wrong, Steve, is, was that written statement prepared by a police officer? Was it prepared by the witness themselves? Was it testimony in another proceeding? Or was it a summary? And you know, I would ask Steve, when you've come across this in your experience, how helpful is it to have the witness there to possibly explain, you know, why the statements appear to be inconsistent?
Well, it can be very helpful, as your question suggests. And in fact, very often you'll see attorneys suggest that there's an inconsistency between two statements or an omission from a prior statement that fails to include a fact that is now being testified to at trial. And sometimes there's a very powerful explanation for why. For example, during the prior interview, the questioner never brought a particular meeting up or brought a subject up because the investigative team hadn't learned about it yet. So having the person there to be confronted with the inconsistency and explain it can go a long way towards helping us evaluate whether the inconsistency is a strong indicator of credibility or not. One of the things I was going to also say is that sometimes we can look at whether there is a motive for the inconsistency. So for example, if we know that the location and date of a meeting is important to the question raised at trial, and our witness tells us one thing on day one, and on day 2 or 3, the witness learns that his cell phone records have been subpoenaed and are going to be reviewed by the government or the investigators or the court before a decision is made. And the witness then says, oh, you know, I made a mistake about where and when the meeting took place. That's an inconsistency that makes me very skeptical, because it seems to be triggered by the notion that the earlier version can be tested against some objective evidence. And so that's just an example of how a motive for the inconsistency or the lack of one can help us decide whether it's reflecting lack of credibility or whether it's an innocent, different recollection on different occasions, just as who authored the statement can often inform the significance of the inconsistency.
about inconsistencies. It's the nature of things in the Bronx where I preside that the vast bulk of the cases I try involve street crime. And identification testimony is very important in those cases. And one of the issues that often comes up is the description that the victim or a witness gave of the appearance of the perpetrator, of the person who committed the crime, becomes critical in determining the accuracy of the identification. And again, this is a situation in which common sense comes into play. What is it that was wrong about the description? If the person says it appeared to be somebody in his 30s and it was somebody in his 60s, that's important. If it's somebody 30s and the statement was that it was somebody who was 28, that's not so important. Facial hair might be important, a tattoo might be important, all of those things. So you have to look and see in this, I keep using the word common sense, but it's very, very important. Is this the kind of mistake that anybody could make? Or is this some indication that it's the wrong person?
When I write an opinion in a case where I'm the finder of fact, I will often say that although Mr. Belkin testified to fact X, I choose not to rely upon that testimony because when he was interviewed before the trial, he denied that fact X was true, or it is clear that it is in his interest to claim that fact X is true, and he had a motive to say that at the trial. But when we look at his records and documents, there's no reference to fact X, and we would have expected to find it there. So I'll say things just like that, in my opinion, to explain why I'm reaching one conclusion of fact rather than another.
Whether the evidence is overwhelming or not is a difficult determination to make in the absence of live witnesses. And you might reach a conclusion simply looking at the dossier that the case is overwhelming, but if the evidence is then tested in the courtroom, it turns out not to be so. There could be issues about the DNA testing or how the DNA sample was acquired, whether the confession was coerced, all kinds of things that won't be readily apparent from just looking at the trial. And if the defendant wants to raise those issues in a courtroom, that ought to happen. I'm just worried about reaching a conclusion that the evidence is overwhelming in the absence of actually presenting the evidence.
I don't want to belabor that point, but I will add that there are times when you look at the pretrial materials and you reach an instinctive, intuitive judgment about how the trial will come out. And then you take the bench and you hear how things unfold and the points that the lawyers raise, and you look at the witnesses testify, and you change your mind and you see things from a different perspective. So I think that there's a certain, I hate to use the word, but it's the only one that's coming to my mind right now. There's a certain arrogance about thinking that as judges, we can figure out whether there is an important dispute of fact or not, and we should decide that this case doesn't need to be tried and the lawyer's just wasting my time by asking for a trial. Because I find that when I'm in the courtroom and I listen to the trial, I'll always learn something new. It may not be enough to change my mind, but sometimes it will be.
So I'll add my perspective as a criminal defense lawyer. Where the defendant is not admitting the facts and is asking for a trial, I think the problem is who gets to decide that oh, in this case, the evidence is so overwhelming that you don't get a trial. But in another case, well, the evidence is not so overwhelming, so you do get a trial. Because the problem is, in order to make that determination, you almost need a trial to decide if the evidence really is overwhelming or not. If you're just looking at, for example, a confession, which is probably the most devastating evidence that there is against a defendant, is a confession to the crime. But truth be told, confessions are not always reliable. There are many, many cases in the United States where it turns out that the confession was unreliable in some way. Maybe it was coerced by the police. Maybe it was done in some psychological coercion, if not a physical coercion, rather, which lead to reliability questions about that confession. So if you were to just look at a confession and say, you don't get a trial, that defendant would never have the opportunity to try to show that there actually is an explanation for that confession, and it is not reliable. It actually was a false confession. Now, that's the minority of cases, but they exist. There are actually quite a few. And so to me, you would need, as a defense lawyer, you would need the opportunity to present that as a possibility. And without a trial, I don't see how you do that. So I think the question is, there's no way for the judges to be the gatekeeper of whether someone gets a trial, because they need to know what's underneath these pieces of paper that they're looking at before they can really make an informed view of whether the evidence is really overwhelming or not. So I think a trial is the best way to do it with live witnesses.
I would just add that there are situations in which there might be overwhelming evidence that the defendant is guilty, but the question is guilty of what? And just an obvious example is in a homicide case where there's no question that the defendant caused the death of the person. There might be an issue as whether he caused it with the intent to cause death and be guilty of murder, or whether he did it with the intent to cause serious physical injury and guilty of only manslaughter, and down the road. So there are subtleties to this that would make a trial necessary, even in a situation where the defendant's involvement in the crime is clear.
So I wanted to make another, or ask a related question. In addition to making the trial the center of a criminal case, that the people should feel fairness and justice in every case. You've described situations where once you've heard the evidence at trial, you've learned something new or it's changed your mind. And I want to ask if you've had questions or experiences where during the trial, questions were raised, but by the end of the trial, your questions and your doubts were satisfied, and that even though you didn't change your mind, the process gave you more confidence in the outcome. And whether there's just a value in having confidence in the outcome, that the defense had every chance, every opportunity to challenge the evidence. They made some points, but at the end of the day, you found the evidence was sufficient. And having given the defense the opportunity to raise every challenge they could, that you felt the jury's verdict, you just felt it more confident.
I take as a very important part of my job, and I think most of my colleagues do as well, enhancing or working toward having the public and the community have confidence in the transparency of what we do and the integrity of what we do. And that's why our courtrooms are open. That's why I think good judges try not to cut lawyers off until they've had a chance to make their point, and why we let both sides have the right to be heard. It's also why we have a confrontation clause in our Constitution that says that every person who is accused of committing a crime has the right to confront the witnesses against them. And I have an example that sticks in my mind, even though I was a brand new judge more than 25 years ago when it happened, and it was a civil case, not a criminal case, but a plaintiff who was seriously injured using a product sued the manufacturer of the product for the damages he sustained from using it. And the trial made pretty clear that he used the product unsafely, and it wasn't the manufacturer's fault that he had such a serious injury. He lost an eye. It was not a minor case. And his wife sat with him during the trial and afterwards wrote me a letter and said, I know my husband lost his case, but having had an opportunity to sit in a courtroom where all of the evidence was put forth and examined and scrutinized by the lawyers for both sides, and knowing that the public or the press could have walked into the courtroom at any time, made me feel like he had a fair day in court and that he had his opportunity to tell his story and to have it tested. And I think that as important as that was to that man, it's even more important when someone is accused of committing a crime, that those who are accusing them be tested and probed, and that the community and the family of the person accused and the accused himself or herself knows that before they're being sentenced to custody, knows that before they're receiving the critical eye of society and their government, that the case against them was tested in an open adversarial way that gives us confidence that the possibility that the paper record doesn't tell the whole story has been explored. And so that's what I would say on that subject.
I think it's important to point out, and it's easy to overgeneralize this, but if a witness essentially says the defendant did it before trial and is going to say at trial the defendant didn't do it, or actually says that at trial, for the most part, the prior statement that the defendant did it is not admissible at the trial. It's not what he said before, it's what he's saying now. There's a limited situation in which, in New York, that witness could be impeached with the prior statement, but it's very limited, and it only is impeachment. It's not direct evidence. There are situations, though, where a witness is recanting, refusing to testify, whatever, where a prosecutor can present evidence in a hearing that takes place outside of the presence of the jury, in which the prosecutor attempts to prove that the defendant directly or indirectly is responsible for the recantation. And if that happens, then that statement, the prior statement, can come into evidence and be used at the trial. So I would just add that on that question.
With respect to the recantation, talk about a reason to have live testimony and not rely on the paper record. If we were relying on the paper record, we would have the accusation untested and not treated in the same, and not put through the rigors of a trial, and we would end up convicting the people of gambling even when that witness now is saying that it didn't happen. I think it enhances the argument or enhances the position that live testimony is of critical value. I'd also revert back to Judge Marcus's comments about burden of proof. That's why we have the proof beyond a reasonable doubt standard when the evidence leaves us uncertain, because we don't know which of many inconsistent versions to believe, then we don't act. And it's where the expression that it's better the innocent, it's better the guilty go free than the innocent are punished comes from. For many witnesses, the mere fact of coming to court, testifying under oath, in front of a judge, in front of the public, and subjecting him or herself to cross-examination is in and of itself a strong indicator of the credibility of the witness. And when the witness won't come forward under those circumstances, it might be a sexual assault victim who is too burdened with shame or embarrassment about what happened, but it might also be an indication that the evidence is unworthy of belief because the witness will not stand behind it.
On the issue of special witnesses, whether it's a sexual assault case, whether it has to do with voluntariness, I would add to that the special problems that arise in identification testimony. There are situations in which an expert witness might testify to help the jury in understanding things that are, the phrase we use is beyond the jury's ken, beyond the jury's understanding in evaluating that kind of testimony and what might explain why things appear to be different than they do. Explain the otherwise inexplicable. So for example, in identification testimony, their expert witnesses have testified about difficulties in cross-racial identification problems. Witnesses of one race have identifying somebody of another race. We've now begun to hear expert testimony about defendants making false inculpatory statements, falsely saying they committed a crime that they didn't commit. More controversial in sexual assault cases, there's expert testimony that's sometimes offered to explain why it is that witnesses don't report a sexual assault right away or otherwise behave in ways that seem inconsistent with sort of a layperson's understanding of how you would react. So those options are available, at least to a limited extent, to explain those cases.
It is true that here, after a defendant is convicted either by a trial or by having pleaded guilty, there is a sentencing phase that's governed by a whole different set of rules than the rules governing a trial. At a trial, the proof of guilt has to be beyond a reasonable doubt. But at sentencing, once the defendant has been found guilty of the crime, additional factors that might influence the sentence only have to be found by the judge, not the jury, by a preponderance of the evidence, which is a lower legal standard. But I would say the issues of credibility and assessing credibility aren't really any different. It's just a lower burden of proof. And it is not uncommon here. You are allowed as a defendant to have yet another hearing at the time of sentencing if you challenge a particular new fact that wasn't determined at the trial that the government wants the judge to consider. You can ask for a hearing where live witnesses are called again on that additional fact. And the judge then has to make a credibility determination, although it's done by a lower standard of proof of preponderance of the evidence.